You're listening to the Valley Current.
I guess educationally, I want to start today by just something that came over the newswire. I forwarded it to people because I was pretty floored when I saw it, which is that there was a $7 billion punitive damages jury award in Dallas State Court, Dallas, Texas, against Spectrum, against the parent company of Spectrum. It's called Charter Communications. It's a cable company. I don't know how many of you have Wi-Fi cable services through companies like Spectrum, AT&T. There's a bunch of them, but Charter is one of them. And an 83-year-old woman was apparently stabbed to death by a company internet installer in 2019. And the estate brought a wrongful death case. The guy was eventually convicted. The estate brought a wrongful death tort claim against him and against his employer. Now, usually an employer is not liable for the intentional tort of a employee unless they had some knowledge or reason to know. Did people see this email from yesterday, or maybe I sent it?
Yeah, I saw it. I read it. Yeah.
Did it shock you? Did it like knock your socks off to see the $7 billion and then they actually wrote out? Because I think the first question would be, is this a typographical error? Is this supposed to be like 7 million? Charter Communications value as an enterprise is something like 70 billion or maybe 79 billion. So it's like 10% of their enterprise value, the entire business value, the entire stock value. Did it shock you? Did that number shock you?
Well, it shocked me for two reasons. Number one, the actual damages award was what, 350 million or something like that?
For an 83-year-old woman who presumably was not even employed, right? Your point?
Well, not employed. And I mean, obviously, I don't know. I'm not a real expert on wrongful death, but I assume her family might be able to get some emotional distress damages or whatever. But first of all, 350 million. I mean, it's ridiculous, number one. And number two, they found, as if I recall correctly, that the company was 90% responsible for her death, and the guy who actually stabbed her was 10% responsible.
Correct.
I mean, come on. I mean, that's just ridiculous. I mean, unless if the guy had stabbed somebody before in murder, or he was a murderer or whatever, I guess, and they said, oh, well, we like to, we want to give you the opportunity to murder somebody else, I guess. But I mean, unless they really had strong evidence that the guy was violent, I mean, and even then, how about 50-50? I mean, how can the person who does the stabbing be 10% responsible for it?
Yeah, I mean, the part that really torqued me, surprised me, is the jury found that Charter had knowingly or intentionally committed forgery with respect to fabricating an electronic arbitration agreement that they said applied. I don't know if they were saying it applied to the mom or it applied to all the kids or what. Presumably, Spectrum provides services in Dallas to all these people. And they supposedly fabricated an arbitration agreement saying this type of tort case would have to go to arbitration as well, where presumably they expected a much lesser exposure on compensatory.
Yeah, I saw that, and I guess I can understand if that's, I mean, who knows whether it's true, but if it is, I can see how that would piss off a jury, but I'm not sure how is that relevant to her, to the wrongful death part of it.
Right.
I mean, it's like litigation misconduct, and I suppose maybe it comes in on impunities. But see, the thing about the 7 million impunities, I mean, the real problem for this company on appeal is is that if the actuals hold up, I mean, the punies are 20 times actuals about approximately. So that is probably a little bit too much for federal due process. I mean, 10 times would be 3.5 billion, right?
Like in your mind, I think what you're saying, Joe, or if I could translate it, the way I would translate it is maybe if it looked more like it was 50-50 and it was 3.5 and then the 10-to-1 ratio applies, at its limit, maybe this could creep under a constitutional attack, but this is like facially subject to a lot of judicial question marks. Was this jury completely outraged beyond the normal outrage that juries sometimes?
Well, yeah, they were outraged. I mean, I don't blame them if all of this is true. I don't blame them for being outraged. It's just that I can't imagine what the damages theory was. Can I take just a few minutes and tell you what this reminds me of?
Yeah, sure.
So do you remember, because I don't think too many, maybe Kim, but I don't think too many people are going to know what I'm talking about. But way back in the 80s, this may even be before your time, Kim, there was that case in Texas that Joe Jamail tried, the famous Texas trial lawyer.
The Pennzoil case? Pennzoil case? Texaco?
Pennzoil and Texaco.
Texaco, yeah.
Mm-hmm. And it was, and I think Pennzoil was the plaintiff, right? And there was some deal over oil fields, I think.
A letter of intent, according to Texaco, and Pennzoil said it was an actual agreement, like a one-page, very simple 1 or 2 pager. Yeah. And
apparently, Pennzoil had Jamail, and Texaco brought in a bunch of New York lawyers, and the witnesses were the guys that did the deal and all this stuff. And the jury ended up awarding Pennzoil, it was something like $2 billion or $3 billion, I think, or maybe it was even more than that. It was in the billions. And in the 80s, it was like the biggest award that had ever come out of a court.
Right.
And the damages analysis was just like, I can't do it justice at this point, but I remember thinking at the time, this is just plain bullshit. I mean, it was just plain unadulterated bullshit. And so the reason why I bring it up is because I remember this was right around the time. Do you remember the Challenger, the space shuttle Challenger blew up in 1986?
Right.
Because I was on my way. I was working on a case with Bill Fenwick, and I was on my way to take depositions in Florida. And that's when this was in the news. And I remember that the Challenger blew up. And when I was in Florida, I can't remember who the opposing counsel was, but he was older than I was, and he wasn't from California. And we were talking about the Pennzoil case, and he said, "Oh yeah," he says, "this is bullshit." He says, "There's no way that the Texas courts are gonna, the appellate courts are gonna uphold that, because they're gonna look like, their juries are a bunch of nutcases."
Right.
And he says that's gonna get overturned. And I was like a third year attorney or whatever. And I was like, well, okay. But it didn't. They upheld it. They upheld that on everything, the damages and everything. And that's how Jamail got to be. I mean, he was probably a rich guy already, but that's how he got to be the richest lawyer in America, because he had it on a contingency.
Right. But it got more complicated, too, because ultimately Texaco went to the federal courts to try to argue that the federal court should view all this as unconstitutional. And I think it even went to the U.S. Supreme Court. I remember vaguely, like they did every procedural activity in the book to try to stop or stay. I think they even filed for bankruptcy under Chapter 11 with the view that they were going to basically try to discharge or reframe it or organize some sort of payment plan. And ultimately, I think they did pay, but a lower number that wasn't $2 billion. Maybe it was, some percentage discount from that. But ultimately, it was a big deal. It was a big deal.
But it wasn't a Punies case, right? It was not punitive damages. It was actual, as I remember, it was actual damages. So I think it was pretty tough for the federal court to get involved, because there was expert testimony about what the damages were, and the court allowed it. And so the Texas courts upheld it under Texas law. And I think, although you get into punitive damages due process through the 14th Amendment for state punies, like we saw in the theft case when we were doing that. But the admissibility, I mean, I don't even remember at that time, was the, what do you call, what's the, I'm not thinking of it.
The U.S. Supreme Court case. I'm just looking up quickly. Jury awards $10.53 billion to Pennzoil in Texaco case, November 1985 is what this is saying.
It was 10.
That's what it says. Texas jury yesterday awarded Pennzoil $10.53 billion in the 1984 battle to buy out Getty Oil by unlawfully subverting a binding contract between Pennzoil and Getty. And I think there were punitive damages. I think it was viewed more like an interference with contract case, because it says something about, that the actual compensatories were far lower and the rest were punitive. So I think that's how they did get.
Oh, maybe there were. Okay. I didn't remember that. I thought it was because I remember thinking that the actuals were bullshit. The way they just, anyway, Daubert is what I'm thinking of. So, but I think that, courts can have their own standards, right? Daubert doesn't necessarily apply in state court unless the state adopts it. So I don't know. And if the punies were, I mean, given that the actuals were in the billions, I'm pretty sure, then the punies probably weren't that out of whack with the actuals. So I don't know. I don't know the arguments, through the federal court system, how they tried to get into the federal court system, because I would think the only way they could do that is by petitioning for cert. If it went up to the Texas Supreme Court, I don't remember whether it went to the Texas Supreme Court. I mean, it went to an appellate court, and I don't remember whether the Texas Supreme Court took it and ruled on it or didn't take it or whatever. But the only way to get into the federal system that I know of at that point would be to go for cert, right? And I don't think the Supreme Court took it under cert, Jack. Do you?
Yeah, I don't remember what played out, but in the back of my mind, they did something in the federal courts, and there is actually a published decision in the Court of Appeal in Texas for how the punitive damages were reduced to a lower number, a remitter of $2 billion. Basically, there's some details here I could provide, but it did eventually go to the Texas Supreme Court, and I think it went from there to the federal court system, which would be right. It would be then to the U.S. Supreme Court on some sort of constitutional challenge, right? Yeah.
So my recollection, I mean, I did remember something like about $2 billion or $3 billion, and the only reason why I read it, that's what this reminded me of, is a Texas case where a jury just went like ape shit and awarded all this money.
Right. This is why juries in Texas in patent cases are worrisome for defendants, because the view is that they end up taking a very loud view if they think there's been misconduct particularly against a Texas owner of patents, right? I mean, that's what you see.
And it looks like it looks like though that the Western District is finished, probably, at least unless there's some other patent judges besides Albright that step up and really try to fast track plaintiffs' cases, because they took the exclusive jurisdiction away from him. I mean, his own district did. Yeah. It wasn't the federal circuit, but his own district decided that they didn't like him taking all the patent cases. So now it gets, if you file in Waco where he's the only judge, which is why everybody was filing in Waco, they could file in Waco. If you file there, it's like the Northern District now. You get scattered around the various branches of the Western District. And there's 12 judges total in the Western District. And so therefore, your odds of getting Albright are low.
Right.
And the other judges at this point apparently don't have much patent experience, which is not surprising, given the only real tech hub there is really in Austin.
Right. But Joe, I wanted to ask you, the reason I brought this up first is if you did the analysis that we did in the theft case, the factors are somewhat similar to the Texas state law factors that are listed here. They list 6 factors. I don't know, net worth of charter. I mean, we talked about net worth a lot in what we were doing in the theft case. But if you look at the double rule, that 2-hurdle rule that you described in the briefing, where you said, net worth is one thing, but then you have to look at kind of what portion of net worth you're actually affecting. And there was kind of a sort of a range that the California cases looked at.
Yeah.
Remind me of what the range was, like what was viewed as the normal range of the net worth. Assume the net worth is like 70 billion for charter.
10%.
It's 10%.
10% was kind of the majority. Most of the cases found that it shouldn't be more than 10% of net worth. There were some that went beyond that were cited, but they were kind of a little bit special cases for various reasons I won't try to enumerate. But the general rule was pretty much it shouldn't be more than 10% of net worth.
Right. And then the second rule had to do with the multiplier against compensatory, which you covered, which is if the compensatory were like whatever they were here, 350 million for an 83-year-old woman, which is a little surprising because maybe she has 7 years left to live. And I doubt that she made 50 million a year as her economic production, right? I mean, compensatory damages, I don't know where or how that number got calculated, but 350 million, if that was the number, maybe it was even a little more than that because 90% was 337 allocable. That was your third objection, that how could it be 90% to the company?
Right.
Even if they did engage in forgery of an end user agreement or whatever it is that they forged to have the arbitration clause in it, supposedly, at least that's what the jury found, which I guess uncaps, according to the law, Texas law uncaps what the punitive damages could be, but the constitutional cap would presumably apply, right?
Yeah, and just because some people appear to be confused, these apply to both corporations and individuals. So there's no doubt under California law that you use 10% regardless of whether it's an individual or a corporation. I don't know what Texas law is, but when you get to federal due process, then again, you're looking at 10-1, regardless of whether it's a corporation or an individual. You're looking at if it's more than 10-1, it's suspect. It's suspect under due process.
Well, this is more than 10-1, right? By any measure, right?
Yeah. So I mean, they just blew past it. I mean, I don't know what the court instructed them. I don't know that you instruct the jury on that, though, Jack. And maybe that's the thing is the judge should now be looking at this on JMO, right? Or motion for new trial.
Right.
Or a motion for a remitted or whatever they move for. The judge should be the one who's looking at that. On the Casey jury instructions, I don't know, Taylor, if you remember, but I don't think they put the percentage in there.
No, I don't think so. That all those cases were appellate cases where the punitive damages award was appealed, as I recall, and that's the metric on appeal. The 10-1 and the 10%. Right. I don't think the jury's instructed as to that.
The judge has to take that on JMO or whatever. Although I suppose you could make an eliminate to say that they can't ask for more. But whatever. I think it's the judge on the ratio, right? Because that's pretty much just a matter of law, not a fact.
Yeah, I mean, to me, it's a noteworthy case because if you're those lawyers, all these rules going into this trial, there's going to be an appeal, that the numbers are big, I don't think you should be overjoyed with what's sometimes called TFM, too effing much. Yeah, TFM. You get a TFM case where it just makes everyone think what happened in that trial department was completely out of whack with any degree of normalcy. And so you go in with kind of a presumption against the validity of the verdict, even though the presumption is typically in favor of the validity of the verdict. I mean, I had a case where we were going to be retained to handle the appeal. And a lot of what happened was a jury came back with a really ginormous punitive damages verdict. And even the plaintiff company that won that verdict was like, we told our lawyers to, like, you know, tone it down. We were worried that if TFM applies, we're not going to have an easy time on appeal. And I remember saying, you know, why didn't they follow it? It says, you know, they just got into their contingent fee, this idea that, you know, they really, really wanted the contingent fee. And it's almost like they lost sight of the client's interest. Yeah. And that's the last remark I'll make about this. If you're the plaintiff's lawyers, are you like happy? Or are you like, God, we pressed the pedal to the metal a little too far? I mean,
well, they had to have asked for it, unless there's some rule in tech. I mean, for the actuals, they had to have asked for that amount. For the punies, I assume you ask for the amount you want. Now, unless there's a rule in Texas that says it's purely up to the jury and you can't even ask for an amount, which I suspect is not true. But so they had to ask for it. Here's what I think. I agree with you to some extent, Jack, but I think that to another extent, because it is so risky when you're up against such a big award like this, I think these big numbers, you know, will scare people into settling if they can get the plaintiff down to something that is not completely crazy in terms of destroying their business or really, you know, rocking their business or whatever. And I mean, if they're worth $70 billion and they got to pay $7 billion in cash, I mean, that's a big deal. The other thing, though, that I agree with you is, I mean, who can these people be that won this case? Why wouldn't 100 million be like an incredible victory for them? And it seems to me that maybe it's the attorneys that would be the ones wanting to push it because they would want the big contingent hit. But it's up to the client ultimately to settle. So I think as a contingent attorney, you're kind of in a little bit of a bind there too. You might want to just get separate counsel to advise the plaintiff on settlement, because I mean, let's just assume $100 million, and it's some people in Texas. I mean, I don't know who they are, and maybe they're already rich, but if they're not, I mean, if you got $100 million, how many people would actually need more than $100 million to be as rich as they want to be, right? So wouldn't it be better to just take that and move on than waiting and having it go up the chain in the appellate process? But you got to be scared if you're the defendant, right? I mean, that was the reason why I brought up that other thing with Pennzoil and Texaco, because, like I said, there were people that were like, that's going to get overturned. But I mean, maybe it did, but it certainly didn't get reduced below the billions.
Yeah, I mean, if you're the lawyers, perhaps you say you want 10%, and then you mention that the company's value is over 70 billion, and then the jury puts together the 7 billion. But I wonder at some level, if you're really protecting the record and you're a bit worried about TFM principles coming in, you say, now look, to be fair, punitive should not be more than 10 times whatever you find on compensatory damages. So if you find, you know, 300 million or 350 million on compensatory, as we've asked for, we're not asking for more than 3.5 billion, even though that's less than 5% of their net worth. And that's lower than the 10%. Like, I wonder if you would go that far, because I think they've generated a lot of press here that probably will put the firm on, you know, on the map. This law firm is certainly going to get a lot of publicity and probably a newspaper.
Well, I would be shocked if somebody wouldn't settle from the plaintiff side for 3.5 billion. I would be, I guess, somewhat surprised if the defendant would agree to that much without more litigation. But the judge, I mean, there's going to be post-trial motions, obviously, and the judge could very well, while upholding the verdict, could very well issue remediator, so that if they want to keep the verdict and not have a new trial, they have to take a lesser amount of actuals and punies. That could happen. I mean, I still, without knowing more, I still can't imagine how you get, for an 83-year-old woman, despite the horror of what happened, which I get it. But I mean, if you're looking at, I mean, it can't be economic harm to the relatives or whoever, kids or whoever were the plaintiffs. It can't be economic. I mean, can't imagine it's economic harm. And she was a brain surgeon or something, and she was still practicing. I think it's got to be something about loss of, emotional distress. I don't know exactly loss of consortium when it's apparent, but it's got to be something like that. Again, it was horrible, and they're entitled to something. But I mean, come on. I mean, come on.
I guess she was using the internet, and living on her own, for whatever that's worth. But I think the median age or the average age for someone who gets to 83 is typically they don't really get beyond 90 or 91. Someone could look at the tables on presumably. But, generally speaking, I think it is a case that's noteworthy, and particularly given the punitive damages award that we talked about yesterday that was leveled against that individual who now is deceased, curiously. I think everyone now does believe that Wheelie is deceased. The 7 billion really is quite a contrast and is noteworthy from an educational point of view, because I think you see this every once in a while where the jury system gets castigated as a roulette wheel, as you don't know what's going to happen. And of course, the other reason this caught my eye is there was a forgery of an electronic document, and we've had that issue in the case. And big companies do sometimes engage in stupid things like forging electronic documents, as apparently was proven in this Texas case. And then that really results in a jury coming down pretty hard, even though you would say, so litigation misconduct, that happens, what's the big deal? It doesn't change the basic facts, which is they hired a guy who was a psychopath and a criminal, and the guy decided to both rob and kill a customer, an 83-year-old woman, and that's sad. But did the company really know or have reason to know that that was going to happen? It's more like the forgery becomes you were trying to cover it up, like you were trying to not face the music. So we're going to hold you 90% liable. Like the chain of logic doesn't really fit that, right? When you think of the chain of logic, how do you get to 90% as a result, right?
Well, if the guy was insane, maybe, in other words, he's sort of not really responsible for his actions like a normal person would be, and you knew that, and you unleashed him on the public. I mean, I just don't get it.
Oh, you'd have to have some HR file that says, hey, this guy has muscled other customers and you should have let him go. He was basically a loose cannon on board ship, and you were negligent in not supervising him, right? Because can you imagine?
Well,
can you imagine Charter or Spectrum, I guess is their trade name, what their conduct must be now, going through all the HR files to see if there's any belligerent behavior at all? Because imagine there's another case that gets filed shortly, even if it's made up by someone who says I was roughed up by an installer as well. Because installers do come into your home to fix your internet, and they are trusted. And it is like they can corner, if you're an 83-year-old woman or even an 83-year-old man, they can corner you and take advantage of you, I suppose.
Sure.
It probably does happen, just like Uber drivers, right?
Yeah, yeah. I mean, you always take a risk, and companies take a risk unless, I mean, unless this guy was an axe murderer that somehow they thought was, reformed or rehabilitated. I mean, I don't know. We don't know the facts, so it's speculation as to what he may or may not have done before and what they knew. But I would have to say, it would have to be pretty bad for me as a juror to say that the guy that killed her was 10% responsible for killing her, and the company that hired him was 90% responsible. I mean, I guess I'd listen to the plaintiff must have had a good argument, I guess.
You would flip it around and say typically the actual tortfeasor, the person committing the tort, is more like 90% responsible, and then maybe the company for failure to supervise is 10%, and then all those numbers would presumably change, as would the ratios, right? Because then you get into, well, if it's 10% of 360, then it's 36 million, and then 10 times 36 million would be 360 million. That's a fraction of the 7 billion.
Yeah.
And I'm sure they must be noodling all those arguments for the motions that will be brought. And I would be shocked if the judge didn't adjust these numbers and set up a negotiation, I suppose. Right?
Again, we don't know. I mean, it could have even been something like the guy was an axe murderer. They didn't know it because they didn't do a good enough background check or something like that. If the guy had murdered, I mean, we're speculating. We don't know.
Right.
But all I'm saying is, for me to even have considered something more than 50-50 in terms of the defendant's liability, there would have had to be some pretty special circumstances. So maybe there were. Who knows?
Yeah, I mean, we don't know the length of the trial. We don't know what the trial transcript shows. We don't know what the arguments were. But we do know it does seem like one of these cases that will go down in the Guinness Book of World Records if it's upheld, like the Texaco case. I mean, there was, of course, almost 40 years ago, or 38 years ago, 37 years ago. And it was 10 billion, and it was corporations, and it was over ownership of another oil company, Getty, and sort of an interference with contract kind of argument, which is a tort. This is more like an intentional first degree kind of murder is what it sounds like, or certainly a second degree murder.
Tune in next time on The Valley Current.